She chose the day. Specifically, she chose a day just before her 18th birthday. She chose to drive the car, the time to drive the car. She chose an obscure, previously scouted route through an industrial parkway. She chose the target to hit and the victims. She chose the means and the method to follow through.
She chose the day just before her 18th birthday. That detail alone should stop you cold. Not a reckless teenager who lost control of a car. Not a tragic accident on a wet road. A 19-year-old sitting in a courtroom, convicted of 2 counts of purposeful, intentional murder. And the judge had just spent the last 10 minutes dismantling every excuse her family had offered, one by one, with the quiet precision of someone who had seen every version of this before and was not impressed by any of them. But before we get to the judge, we need to talk about what happened when Mackenzie's mother stood up to speak. Because that moment, that specific, uncomfortable, extraordinary moment, tells you everything you need to know about why this case became something far larger than a sentencing hearing. The mother's name is Natalie Sharilla.
I just want to say, am I allowed to address them at all?
Sure.
I just want to say to the families that I'm broken, sad, and lost, and my heart hurts for everyone, okay? Davion was her new friend, and Dom was the love of her life, and he was part of our family, okay? I'm just so sorry that this happened, and we're heartbroken, okay? And then, Your Honor, this was a terrible, tragic nightmare accident to have happened that she has no memory of, and she will never...
She is not a villain in the conventional sense. She is a mother who loves her daughter. And that love, expressed in a courtroom full of grieving people, became the most revealing thing anyone said all day. She spoke about the shrine Mackenzie had built next to her bed, photos of Dominic, his favorite snacks, a light-up flower he had given her because he wanted something to stay fresh and alive forever. She spoke about how Mackenzie wore his clothes for 3 months.
Halloween, for 3 months after the accident, she would only wear his clothes. She would only eat the snacks he ate. She would only listen to the music he wrote, okay? She was laying in bed for 3 months crying. There was a shrine of him next to her with photos and things that he liked and this flower that lights up that he got her because he wanted it to be fresh and alive forever. It's like a little Beauty and the Beast flower. Okay, she's got this shrine of him next to her. So she was crying for 3 months. So her friends asked if she wanted...
She spoke about the concert and Halloween and how everything Mackenzie did after July 31st was in honor of him, to be close to him, to carry him forward. It was, in its way, a genuinely heartbreaking portrait of grief. And then the judge stopped her. Not gently, not with a procedural note. He stopped her mid-sentence and said,
I'm hearing an awful lot about your daughter. I'm not hearing very much about the 2 dead people.
Dominic, okay, I'm asking you for leniency because this was a tragic accident that she does not remember. And Davion, he's a new friend. And I'm so sorry.
What does that mean? His life is worthless?
No. Okay. God, no, not at all. They all loved each other. They all spent every day together. You know what I mean? I don't.
I'm hearing an awful lot about your daughter. I'm not hearing very much about the 2 dead people. The room absorbed that. And then Natalie Sharilla said something that the judge would return to moments later. She mentioned Devon Flanagan, the second victim, 19 years old, adopted from foster care. A young man his mother described as,
I am the mother of the victim, Davion Flanagan. I want to share a small part of what we lost on 7/31/2022. My son, Davion, is and always will be so much more than cargo.
A friend to everyone who crossed his path, and she referred to him as Mackenzie's new friend. The judge asked what that meant. She said she was sorry. He asked directly, does that mean his life is worth less? She said, no, of course not. And the judge said quietly, isn't that part of the problem? That they all trusted each other. That's how they all ended up in the car. And 2 of them ended up dead. We're going to have to disagree on that, he said. And he moved on. Now, here is where understanding a few legal terms will make everything that follows land harder. This hearing was a sentencing proceeding under Ohio Revised Code Section 290302A. That is the Ohio statute for murder, specifically the purposeful causing of another person's death. Purposeful is a precise legal word. It does not mean angry. It does not mean reckless. It means the defendant consciously chose this outcome as their specific goal. The jury had already decided that. The conviction was locked.
No one wanted this to be a murder or to punish Mackenzie Shirilla for this accident. But this was not a car accident. The evidence and science proved that Mackenzie Shirilla murdered my son, Dominic, as well as Davion. There's no fix put in this case, as the Shirillas would like to proclaim. I want to thank Strongsville Police Department and the state of Ohio for seeking the truth behind this crash. Thanks to them, we all know what happened in that car that day. What we don't know is why.
The only question before this judge today was whether Mackenzie's 2 murder sentences, 15 years to life each, would run consecutively or concurrently. Consecutive means one after the other, so 30 years before parole eligibility. Concurrent means both sentences run at the same time, so 15 years before parole eligibility. That gap is the entire stakes of this proceeding. The defense attorney, to his credit, made the strongest argument available to him. He pointed to letters from juvenile court staff who had supervised Mackenzie during her 9 months in detention, letters describing her as a model inmate.
We actually see where both of them say that she expressed remorse during the time. What the prosecutor played there was after the accident and way before she was ever incarcerated. They also both say that they have observed her grow as a person, that she's taken every single class possible, both culinary and college, that she's actually been a model inmate, the letters say, and that she has exhibited what they call the highest level of behavior. They grade people 1, 2, 3, 4. The better your behavior, the higher the number.
The highest behavioral rating possible. Someone who had taken every class offered and been receptive to counseling. He argued that the brain does not fully develop until age 25, that her choices reflected teenage invincibility rather than adult malice. He noted she had no prior criminal record. He asked for concurrent sentences.
Here are up to you. You have a range of possibilities as it relates to a girl who was 17 at the time, who is now 19 years old and has no criminal record. And as you so correctly pointed out in the opening, the decision when she gets out is up to the parole board. And we know how the parole board operates, and we know that everybody gets flopped at least once. So a 15-year sentence becomes a 20-year sentence at minimum. And it'll be up to this young lady here as to how she's going to conduct herself for the next 20 years or whatever the sentence would be.
He said he had personally witnessed true remorse and said so as an officer of the court. It was a competent argument. The judge had clearly read every letter, and he was about to explain, methodically and without raising his voice, exactly why none of it was sufficient. But first, and this is the moment that the prosecution had been building toward all morning, there was the matter of what Mackenzie had actually done.
Kenzie's statement in the hospital to Detective Azu, "Can't you just take my license away for 10 years or something?" That statement is Mackenzie Shirilla. The most selfish person I know. Ironically, Dom was the most selfless person I know.
In the weeks and months after 2 people died in that car, the prosecutor introduced evidence of a social media post.
Shortly after the crash, Strongsville police were notified that they had received concerning emails from the community that the defendant and her mother were seeking employment with the Los Angeles modeling agency. Kenzie Shirilla said to Vitaly. Thank you for the comment. I would love to work with you guys. I've been emailing you guys a lot. Such a great opportunity. Thank you.
Is there a date?
There is not a date on this, Your Honor. Based on the investigation, it was delivered to the police while the defendant was still in the Metro Health Hospital. So it was during that time period. She was in the hospital for several weeks.
In which Mackenzie, while still hospitalized at Metro Health, had responded to a Los Angeles modeling agency. Thank you for the comment. I would love to work with you guys. I've been emailing you a lot. Such a great opportunity. The defense objected. None of this was introduced at trial. The judge allowed it for the limited purpose of demonstrating remorse, or the absence of it. Then came the concert footage.
Shortly after being released from the hospital, the police were provided additional videos of the defendant from her wheelchair as she attended a concert down in the Flats. And again, Your Honor, I'm introducing these to the court to show the shocking lack of remorse. This was something that was being exhibited while the investigation was still going on, before she was charged and arrested in November of last year. And these were the sort of things that were coming to the police, and the shocking lack of...
Mackenzie, in a wheelchair, at a concert in the Flats. Then Halloween photos from Ohio University, before she had even been charged. The prosecutor used one phrase 4 times in his presentation. Shocking lack of remorse. He said it like a verdict that had already been rendered. And here is the question I want you to sit with, because I think it is genuinely more complicated than it appears. If a teenager kills someone she loved, the boy she called her soulmate, and then attends a concert that his cousin organized in his memory, is that evidence of remorse or evidence of its absence? Where exactly is the line between honoring someone and moving on from them? Drop your answer in the comments, because reasonable people have genuinely disagreed on this, and I think the answer says a lot about how we think about grief, guilt, and justice simultaneously. We are now at the moment this entire proceeding has been building toward. The families have spoken. The prosecutor has presented his evidence. The defense has made its argument. Mackenzie has spoken, briefly, seated, saying she would never have let this happen on purpose, that she wishes she could remember, that Dom was her soulmate. And now the judge begins to speak. What follows is one of the most methodical, precise, and quietly devastating sentencing statements you will find in a case like this. He began with the weight of the room.
Today is the sentencing of the defendant for the purposeful and intentional murders of Davion Flanagan and Dominic Rousseau. And in a way, it's the second time their families are gathered again to grieve. It's also a day when Mackenzie's family will grieve for the future of their daughter. All 3 of these families and the friends of these families are suffering, and all of their lives have been irrevocably changed because of the actions of the defendant.
3 families, all suffering, all irrevocably changed. He said the defendant's decision was selfish, intentional, and cruel, and that its consequences would ripple forever in time. Then he said this: if any reasonable person reviews Exhibit 802, there can be no doubt what happened that night. There can be no doubt of the absolute terror of the 2 people in that car. Then he listed what the evidence showed. She chose the day. Specifically, she chose a day just before her 18th birthday. She chose the route, an obscure, previously scouted industrial parkway. She chose the target. She chose the means. She planned it, and she executed it. The judge then addressed the medical condition defense directly. No medical condition caused this as an accident. No mechanical failure. The record is clear. And then he said something that has the weight of a law school lecture compressed into 2 sentences. Even if Mackenzie intended to also die in this crash, that is irrelevant. A failed suicide attempt is not a defense to murder.
It is also important to remember that even if Mackenzie intended to also die in this crash, that is irrelevant. A failed suicide attempt is not a defense to murder. And even in a murder-suicide attempt, when the perpetrator executing the plan survives, the other death or deaths are still murder.
This is a legal principle that surprises people, so let's make it plain. In Ohio, and in most jurisdictions, if you set out to kill yourself and someone else dies as a result of your plan, you are still criminally responsible for that death. The law does not treat shared intent to die as a mitigating factor. The two people in that car did not consent to die. Their terror was real, and the person who put them there bears full legal responsibility.
There's only one person who's responsible for the pain of everyone in this room, and that person is you, Mackenzie. Nobody else is responsible. This isn't the fault of Dominic's family, or Davion's family, or your family. And I know that each of you have asked your questions to yourselves, what if? What if I had done this or that? The truth of it is, none of us can control the intentions of another. And when there is a purposeful intent to harm or kill someone, it is the perpetrator alone who bears the responsibility.
Regardless of what she intended for herself. Then came the moment the room had been waiting for. The judge turned to the question of consecutive versus concurrent sentencing. He said he was troubled. He acknowledged that a concurrent sentence might appear disrespectful to one of the victims. He acknowledged the weight of the room's grief and the family's desire for the harshest possible outcome. And then he said something that the defense had not expected.
There's a very good likelihood, Mackenzie, that you will spend the rest of your life in prison. That won't be up to me. That will be up to the parole board, and that will be up to you to a great extent. I understand that the pain in this room wants me to impose the harshest sentence, but I don't believe that would be.
And that the families, in their pain, may not have fully absorbed in the moment. There is a very good likelihood, Mackenzie, that you will spend the rest of your life in prison. That won't be up to me. That will be up to the parole board. And that will be up to you. He sentenced her to 15 years to life on each count, to be served concurrently. 30 years collapsed into 15 before parole eligibility. But the judge's meaning was precise and deliberate. The parole board almost never releases someone on a first hearing for a crime like this. The defense attorney had acknowledged as much. Everyone gets denied at least once, meaning 15 years becomes 20 at minimum. The judge was not being lenient. He was being honest about how the system actually works, and he was placing the weight of her future directly on her own choices going forward. This is the legal lesson that matters most, and it is one you should carry with you. In cases involving multiple counts, the decision to run sentences consecutively or concurrently is often the most consequential discretionary choice a judge makes. It is not about the verdict. It is not about guilt. It is about how the architecture of punishment gets assembled once guilt is established. And in this case, the judge chose to exercise that discretion not in the direction the families wanted, but in the direction he believed the evidence, the law, and the actual mechanics of the parole system warranted. He read every letter. He watched every piece of evidence. He interrupted a mother mid-speech to redirect her attention to the dead. And then he made a choice that was calm, deliberate, and grounded entirely in the record before him. That is what judicial temperament looks like when it is working correctly. Not theater, not rage, not performance. Just a person doing an almost unbearable job with precision and without flinching. The next time you watch a sentencing hearing and feel the urge to measure justice by how long the sentence is, remember this. The number on the paper is not always the whole story. Sometimes the most meaningful thing a judge says is what happens after you get out is going to be up to you. Because in this courtroom, on this day, that was the sentence within the sentence. And Mackenzie Shirilla will be living inside both of them for a very long time.